Right. Ladies and gentlemen, welcome to this information session on the new regime for expert evidence in Supreme Court Criminal Proceedings. It's very pleasing to see so many of you here in person. We have just over 100, I think, and another 200 or so online. So the response has been wonderful. So thank you very much for that. You'll notice that I'm joined by Justice Badis, as well as a panel of practitioners, Philip McCarthy KC, the Acting Director, I think, of the DPP currently, Jeff Hunter KC representing the Bar, and Jacob Lodziak, who's of course the Acting Public Defender. Could I just start by mentioning what we have in mind so far as format is concerned? I thought I would stand here and read the practice direction word for word. No, not quite. I'll speak a little about the background to it and the nature of the problem that we hope it addresses and how we think it might operate in practice. Justice Badis will then speak about what is an important focus of the practice direction, that is narrowing the issue for expert opinion. And then Philip, Jeff and Jacob will add any observations they wish to make, following which we'll open the floor up for questions. So why? Why do we need a new regime for expert evidence? Well, on one level at least, these names provide an answer. Each was wrongly convicted of serious crimes in Australia, based in part and in some cases in substantial part on forensic evidence that was later found to be unreliable. Most are relatively well-known examples of miscarriages of justice. One you may not be familiar with is right in the middle, Colin Ross. He was convicted just over 100 years ago, in 1922, of the rape and murder of a 12-year-old girl in Melbourne. He owned a wine bar in the city in Melbourne. He just called it the Wine Saloon. He was accused of the murder of the young girl, but he had what most would regard as a very solid alibi. And unfortunately for him, his was one of the first cases, if not the first, in this country to put on hair comparison evidence. And that was advanced to the jury and very much underpinned his conviction and destroyed his alibi. Strands of hair said to have been from the young girl were found on a blanket in his saloon. He was convicted and sentenced to death by hanging, and he sought leave to appeal to the Privy Council, and leave was refused. He was executed on the 24th of April 1922. He suffered a horrible death. The hangman didn't do a very good job. Estimates were that it took between 8 and 20 minutes for him to die of asphyxiation. Decades later, a retired school teacher became interested in his case, and remarkably, a file was unearthed which contained the original hair samples. DNA testing was performed by the Victorian Institute of Forensic Medicine in 1998. And yes, you guessed it, the hair had not come from the child. He was pardoned in 2008. Too late, of course. The point is, there are these cases we know about, and without more, of course, they provide a good reason for us to be doing what we can to enhance the quality and reliability of forensic evidence advanced to juries at trials. But more fundamentally, yesterday, you will have received an email reminder for this session, which included a link to an article published in the most recent edition of Hearsay. And if you found time to look at that, you would have seen an outline, at least, of the problem to which Practice Direction 14 responds. You will have seen in particular reference to two reports from the United States. The first in 2009 by the National Academy of Sciences, commonly referred to as the NAS report, and a follow-up report from the President's Council of Advisors on Science and Technology in 2016, the PCAST report. Many of you will be familiar with both reports, of course, but if not, if you get some time, click on the link. They are highly reputable, thoroughly researched and authoritative reports, and they send a shockwave through the forensic science community around the globe and should have had the same effect on anyone practicing in the criminal courts. This is from the preface to the NAS report. The authors wasted no time getting to the point. With the exception of nuclear DNA analysis, no forensic method, no method has been rigorously shown to have the capacity to consistently and with a high degree of certainty demonstrate a connection between evidence and a specific individual or source. So leaving aside nuclear DNA profiling, no forensic method could be regarded as reliable. Just think of that for a moment. Fingerprints, blood pattern analysis, the hair comparison evidence in Mr. Ross's case, handwriting, firearm marks, tread patterns, the list goes on. The PCAST report in particular, which was the second report, found that again, putting DNA evidence to one side, there were serious flaws in all of the feature comparison methods examined by the Council. And I hasten to add that we're concerned here in the main with methodology. No one is suggesting that the science underlying fingerprint comparison evidence, for example, is flawed. It's not. But the methodology used does not always give rise to reliable results. In this area, there is, of course, much talk about junk science, but the problem we're dealing with goes much deeper than that. Junk science, an example of which might be gait analysis evidence, it will always be red flagged. We will see it for what it is because it's novel, and therefore we'll look at it more closely. But the reason this problem runs deeper is because the concerns about reliability extend to frequently encountered and familiar types of comparison evidence. So what do we mean when we speak of evidence being reliable? We'll continue the feature comparison evidence example. We mean the method must be accurate, it must get the right answer, repeatable, it must get the same answer from the same sample, reproducible, it must get the same answer across different analyses, sensitive, it must detect a difference if there is one, and specific, it must only provide a result for the targeted sample. Even then, there will almost always be accompanying limitations, including quality issues in relation to the sample, and in every case, a margin for error. This is especially so because in the vast majority of comparison methods, the end opinion relies on a subjective assessment. The short point is this: to be reliable, there's a lot to get right, and therefore a lot that can go wrong. Practice Direction 14 is intended to expose what is right, what might have gone wrong, and the limitations associated with the particular analysis reported on. And then there's a further aspect to all of this. The evidence assembled in support of the vast majority of serious crime prosecutions in this country includes almost always some form of forensic evidence. And yet almost every accused to these prosecutions is legally aided. Only rarely is funding advanced to properly comprehend, test or challenge that evidence. Moreover, with few exceptions, counsel are not equipped by training or learning to mount an effective challenge to forensic evidence without expert assistance, and judges are in no better position. These constraints mean that more often than not, forensic evidence is not properly scrutinised by the defence or tested in court, and in many cases not challenged at all. So plainly enough, if the defence don't question the scientific foundation or reliability of particular expert evidence, the jury have no real alternative but to treat the evidence as reliable. In turn, the comfort usually provided by the existence of avenues of appeal really becomes no comfort at all, because there is no evidentiary basis from the trial upon which to challenge that expert evidence if it has gone through without a murmur. It should also not be assumed that prosecutors, because they lead this evidence, are necessarily in any better position to scrutinise it. They're very much reliant on what they're told about the effect of the evidence. So we have this imbalance, and not across the bar table necessarily, but between scientists and non-scientists, between the fully informed and the not so well informed. So in a nutshell, Practice Direction 14 is an attempt to right the imbalance. It contains detailed specifications of what every expert report must contain, including a comprehensive statement of all limitations in methodology or analysis, and the expression of any qualification to the opinion recorded in the report, without which the report would or might be incomplete or misleading. It also establishes procedures to enable defence counsel to confer with prosecution experts, and it is importantly intended to encourage the early identification of disputed forensic issues and help focus the expert evidence on those issues which are genuinely in dispute in the trial. It was developed, as you see, or as a product of the Court's Forensic Evidence Working Group, and you will see that it was comprised of the Chief Forensic Pathologists, representatives of Forensic Science Queensland, Forensic Medicine Queensland, police, judges, and legal practitioners. It should also be acknowledged that it is closely modelled, that is the practice direction, on a practice note that was published in Victoria in 2014. It's around 10 years ago, and has been revised in several respects over time. A similar step was taken in the United Kingdom in 2011. So those jurisdictions, England and Victoria, very much led the way in terms of court regulation, specifying what needs to be exposed in expert reports. Let's turn to some specifics then. It commences in operation on 15 July. It applies to any proceeding in the Supreme Court, commenced by an indictment presented on or after that date. It does not apply to sentences. It does apply to evidence to be adduced at any pre-trial hearing. You will have seen from a slide or two before that from the constitution of the Forensic Evidence Working Group, that the requirements of the practice direction, and they are onerous, will not come as any surprise to those responsible for the preparation of the bulk of the expert reports that are advanced by the Crown to the defence in this state. Those people are in the loop, and they have been gearing up to meet these increased comprehensive reporting requirements. Just going through a few aspects of the practice direction, it makes it clear, if it wasn't already, that experts have an overriding duty to assist the court to be impartial, to give objective, unbiased opinions on matters within their specialised field of knowledge. And that includes an obligation to inform all parties and the court if and whenever the expert's opinion changes. That is, the practice direction, applies to any expert report on which the prosecution or an accused person intends to rely at the trial. Importantly, there is a distinction in the practice direction between forensic reports and expert reports. All forensic reports are of their nature expert reports, but there is a particular type of expert report, a forensic report, which is singled out for attention in the practice direction. That is a report which is, and I'll read from the definition, prepared in the course of an investigation into an alleged offence by a person with specialised knowledge or training, setting out the results of the examination, etc. An example is given of an autopsy report being a forensic report. So you would understand that an autopsy report will cover a range of things. It's prepared during the course of the investigation. But the way the practice direction works is that there is facility to call upon, for the defence to call upon the Crown to obtain an expert report regarding an aspect of the forensic report. Another example might be a report by a scientific officer, expert in his or her field, about the crime scene. And you will all have seen those lengthy reports, and there's a couple of paragraphs at the end about, oh, by the way, there was all this blood splatter and this is what it means. It's another example of the scenes of crime report or statement being a forensic report. The defence would be entitled to ask the Crown to obtain an expert report on that aspect of it. So it's important to an understanding of how the practice direction works to keep that distinction in your mind. So a request can be made by the defence, the Crown will consider it. If the Crown refuses, then an application can be made to the court for a direction that an expert report be obtained on that particular issue. I should point out, of course, lest it be thought this is all one-sided, nothing at all in this practice direction prevents the defence from obtaining their own reports. That's expressly preserved. The key to how all of this works, however, involves the content of the reports. The idea is to fully expose the opinion expressed and the bases for it. As I hinted earlier, there can be no adequate substitute for reading through what is required in the practice direction. It's a long shopping list of requirements. All of them are important, but let me highlight some features. For every report, all standards, assumptions, qualifications, limitations, or the like must be included. There needs to be a declaration that the expert has made all the inquiries and considered all the issues which the expert believes are desirable and appropriate, and that no matters of significance which the expert regards as relevant have, to the knowledge of the expert, been withheld. Any limitation or uncertainty affecting the validity or reliability of the methodology used is to be exposed, and where the expert is aware of any significant and recognised disagreement or controversy within the particular field of specialised knowledge which is directly relevant to his or her ability, the expert must disclose that. Where the expert's opinion is of a scientific, medical or technical nature, and the vast majority of reports about which we are concerned will satisfy that description, the report is required to additionally state whether, and if so, how, the method relied on by the expert in forming the opinion has been validated in conditions consistent with its intended use. And so I'm talking a lot about reports here, but ultimately that provides the basis for the evidence that is advanced to a jury. So I'm sure you all understand that. Lastly, before expert evidence can be adduced at trial, the party intending to rely on it should make appropriate inquiries of the expert so that the party is in a position, if asked by the judge, to indicate whether the evidence is scientifically valid and or whether the expert has demonstrated the requisite proficiency to do the underlying testing and render the opinion. The practice direction tells us what scientifically valid means. And you will see that 3 of the 5 hallmarks, in fact, the central 3 of reliability appear there: repeatable, reproducible, accurate, and then accompanying all of that, proficiency on the part of the expert. So far as some mechanical things are concerned, service, this won't surprise you, but as early as reasonably practicable. But for primary reports, at least 28 days before any pre-trial hearing at which the report is to be relied on, and at least 60 days before the trial, so 2 months. For responding reports, at least 14 days before the relevant hearing. So far as access to material is concerned, the recipient of an expert report may request a copy of or inspect everything in effect, all instructions and material given to the expert, along with any notes made by or on behalf of the expert, any records of examinations, measurements, tests, and indeed the thing examined, measured or tested can be inspected by the recipient party. The recipient party may also request contact details for the expert to facilitate a meeting with that expert if requested. The expert's not obliged to meet, although it'd be surprising if the expert refused, and the conditions under which the meeting is to take place can be agreed by the parties or settled by the court. By that, what's meant is that it may be, for example, the Crown would like a representative present during that meeting, and that might be something the Crown asks for. If there's argument about that, then the court can settle it. A really important part of the practice direction I've misdescribed as agreed facts. That should be agreed or disputed facts. So the way this works is there is an obligation on the parties to confer in order to determine whether agreement can be reached on a statement of facts, which includes agreed facts, can include agreed facts and facts which are in dispute. The idea is that that can be agreed, that can be provided to the expert, and the expert invited by either party to review his or her findings in light of those facts. And specific questions can be asked of the expert. So you could imagine how that might work. The expert's given a report which has been served or provided or disclosed to the defence, and there's a particular factual foundation for the opinions expressed. The defence, or indeed the Crown, want the expert to consider the position if the facts were different or supplemented in some way. And so a statement of facts agreed or in dispute, but a statement, a foundation for that opinion supplied to the expert, and the expert can be asked to express an opinion about that. The parties aren't required to reach agreement, but they are required to confer in the hope that agreement can be reached. Importantly, An accused person is not required through this process to reveal any aspect of his or her defence, and that's a consistent theme running through the practice direction. This part of the practice direction is all about narrowing the issues. And the last feature I want to point out concerns what I've described as joint opinions. So where the Crown and the defence intend to rely on expert evidence on the same issue or on related issues and the accused consents, the court may direct the experts to discuss the forensic issues in the proceedings and prepare a statement for the court which identifies the matters on which they agree, the matters on which they do not agree, and their individual reasons for any dispute. The court can convene a hearing to clarify this or assist, or in fact direct the experts to narrow the issues of agreement. So this would be a case where there are experts on both sides of the record, the issue has been narrowed, and the court can order that there be a joint report from both experts saying, these are the things we agree on, these are the things we don't, here are our individual reasons for not agreeing on those things. And of course that produces a joint report which then forms the basis for the evidence ultimately given at a pre-trial hearing or trial. This will alarm you if any of you have read the practice direction. For old people like me, it contemplates evidence being given by experts concurrently. There's hot tubbing. That's been a practice in New South Wales for a long time. How that would work here, I don't know, probably not in my time, but there is provision to do that. But it will only be where the accused consents and the court orders that it's appropriate for that to happen. I can see that that might be a very useful thing to do at a 590AA hearing where you have competing expert opinions and the court directs that there be concurrent evidence by those experts. I can't see it working in front of a jury, but it does in other jurisdictions. So I hope that overview assists to some degree. I'll hand over now to Justice Padis.
I only intend to speak about three things because I think it's important to open questions to the floor so you can ask questions. The first is to say that Justice Burns should be congratulated for steering through this very important initiative. The second is that artificial intelligence is not going to change this. I went to a conference recently where a forensic scientist said that there will always be a need for somebody to come to court and explain these things because artificial intelligence is based on a system which in itself has to be explained. And the third is to keep in mind the central thrust of this practice direction, which is to narrow down the issues. And that has an importance, particularly when you think of some of the items. So, for example, if you have a number of samples throughout a house, but you think of what truly is the issue, consideration needs to be given to whether the expert actually has to deal with all of the samples or only some of the samples. And that's a very important matter that has to be considered. So if the accused says, I have never been to that house before, I have never had any relationship with anybody in that house before, and there are samples in the bedroom where it is said that the killing took place, identifying what has happened with those samples may be the most important thing and give an answer in respect of it. Because if the accused's DNA is in those samples, it may be rather difficult to explain. So the blood trail down the hallway and out the front stairs is not the issue. And that is very important now because we have to face the reality, and that is that the DNA is an enormous problem in Queensland. And the way things are, if we continue as we are, they will never catch up. At Streamlining Criminal Justice recently, I was told of an example in the Magistrates Court involving a rape complainant, where the estimate is that the DNA will be provided in August 2025. That is not a justice system. We have to address that problem. News for all will be that the courts, all three courts, are looking at doing just that. And that is that they will start as a pilot project in relation to sexual matters in the district court, that there will be review hearings where counsel will be required to attend, and the identification of what actually is the dispute in terms of the DNA will be identified. If, for example, the case is a rape case where the accused is saying, I did not have intercourse, and there's a high vaginal swab, it may well be that that is the only thing that is initially tested, because depending on the result, that may change how the matter progresses. Speaking to forensic services, it is the only way we will get ahead, because if forensic services is required to do all 50 samples, in a particular case, they only have a finite number of people who can report, and it will be years before any cases will go ahead. And the bar and the criminal solicitors will dry up of work. At the moment, there's something like 100 plus murder, manslaughter matters in the magistrates' court that are not progressing because of the DNA. So we have to face reality, and this practice direction is a good example of where the profession has to jump on board, be cooperative, and really think about what truly is the issue and narrowing down what the expert is to consider. Thank you.
Thank you. I'll just, before we turn over to questions, ask Phil, Jeff and Jacob whether they want to make any comments. Phil, fantastic idea.
Yes.
Yeah, there you go.
So hello. As you can see, the practice direction makes a lot of common sense in any event. We would have been expecting experts to be doing this, and it can only enhance the quality of information given to the parties. His Honour made a very astute observation. The prosecution is in no better position for the defence as lawyers. We heavily rely upon that expertise of our scientists to give us accurate information, to give us comprehensive information, and to give a clarity in terms of their description of their independent opinion, and particularly the scientific foundation for opinion. Now, on both sides, we've all had that encompassed when we're talking to experts. We're not well equipped to drill in through 100 medical journals to try and identify where the competition is in the science for different aspects. I suspect between the three of us up here, we've had that experience where we've had to start looking at medical journals for ourselves. And then when we go to the experts for both defence and for the prosecution and said, you know, we found this journal, what do you say about that? And I've had that personal experience from both experts for the Crown and Defence, where they went, oh yeah, we know about that report. Can we explain it to you? The point made well by His Honour is this practice direction should hone them to have given it to us in the first place, to have identified that information and given us an explanation as to why it does matter materially to their opinion or not. And I'm not being deprecating to our profession. We're not scientists. They are. They're the experts. And we really rely heavily upon the quality of that information. And we don't really have that time or inclination to become scientists in different areas of expertise such that we can combat with them in their field of expertise in those circumstances. So particularly from my perspective, when I read the practice direction, a lot of it simply is what I learned and would expect experts to have done in their reports in the first place, to have identified the field of contest, to have identified the reliability of their science, to identify the scientific foundation for their expert opinion. And so I personally don't see, I think this is great. It's going to hone the scientists to the very thing that we want them to do from both parties so that we get the reports, and when we're getting it, we're getting all that information, and we're going to get more accurate and better information placed before jurors, and particularly the persons making the determination of the result in the particular case.
Can I just add to that the Victorian experience is that the scientists really wanted this. They wanted to know what the ground rules were. They wanted to know how much information to provide, and they've been assisted in doing that. And so their reports, they're used to the system working, and what needs to be in every report, what needs to be covered. And we expect that's going to take time in Queensland until everyone gets used to it. We've given there's some lead time. The people on the Forensic Evidence Working Group are all agreed this is a good idea and have gone away, and they're trying to gear up, as I said, to produce reports that expose all of this as we require them to. But that will take, there'll be some teething issues. We'll review the operation of the practice direction inside 6 months anyway for that purpose. But the reaction in Victoria was the scientists themselves were very grateful that they were given these guidelines for the preparation of their reports. So we expect the same thing will happen here. Jeff?
Judge, can I say that from the defence bar's perspective, I have nothing but positive comments about this initiative. We're really looking forward to it. And just following up on what Phil was, sorry, and what Phil was saying just now about what we expect experts to do, the sad reality is that they don't always do that. And but for a process like this, they're not always found out. And there's a fairly recent case at Pentland, which is available to read because it was a judge-only trial. Pentland was charged with murdering a business associate in 1997. He wasn't tried until 2020. When he was finally arrested and charged in 2019, a ballistics expert purported to say that the projectiles recovered from the body of the deceased were isotopically indistinguishable from some ammunition that was found in possession of an associate of the deceased. And there was a lot of talk about how in Sweden they make these bullets from recycled lead and therefore batches of projectiles are isotopically unique. And so in a circumstantial case against Mr. Pentland, the fact that there was this similarity between the ammunition and the projectiles that had killed the deceased was really very significant. And it was very plausible. It was enough to persuade a judge of the Supreme Court that he should not be granted bail, notwithstanding that the offence had happened 20 odd years ago. And the problem was that it was all just nonsense. It was this expert's pet theory, and the defendant was lucky because he was very well resourced and he had a very competent King's Counsel and competent solicitors, some of whom I think are in the room tonight. And they got their own expert, and they demonstrated that this was just a pet theory of this fellow and had no proper basis in science. And the net result was in the end that the Crown didn't even lead the evidence. But I wonder what might have happened if he had been an indigent defendant and his lawyers had to butt up against the almost impregnable defences of the Legal Aid Grants Department to try and get an expert report. So that expert would have been exposed under this regime, and that's why it's to be applauded. So that's really all I've got to say.
Thank you. And so in that theme, there's probably no worse example in this country than the Chamberlains, is there? I mean, that case involved a compelling body of lay evidence that established that Lindy Chamberlain had nothing to do with the death of Azaria, a compelling body of evidence, but it was trumped by forensic wizardry and expert evidence. The jury ignored the lay evidence. And if you're interested in that, the Morling, which is the Royal Commission report, the Morling report goes into it in chapter and verse. It was a compelling body of lay evidence, but the effect of the scientific evidence on the jury trumped all of it in their minds. So that's the white coat effect. That's why we need to be especially careful before allowing forensic evidence that's not demonstrated to be reliable to be placed before juries. Jacob.
I agree. It's undoubtedly a welcome practice direction. If it achieves better quality expert evidence and evidence that's more reliable, it'll ultimately also lead to time savings and savings to the public purse. And importantly, provide for greater confidence in our system. Justice Burns referred to junk science. Interestingly, recently, Brisbane Times reproduced an opinion piece prepared by a couple of law professors from New South Wales titled "Junk Science is being used in courtrooms across Australia. We should all be worried." In that piece, they said, among other things, forensic scientists can implicate defendants without reference to validation studies and without appropriate caveats. Courts are often shielded from error rates and scientific criticism. This practice direction will surely address those sorts of concerns and many others. It will mean approaching this area of our work differently, but we should all embrace that because in the end, it will ultimately improve things for our courts and the people who appear before them.
Let's make one more
Yes,
observation.
of course.
The only other observation I'd make is a comment voiced on it. Justice Badice narrow the issues. This is not a response to every expert report you get. If it doesn't matter in your case, for the same reason with DNA, you're just going to burden the scientific community by demanding better and more comprehensive reports. Don't do that simply because you can. And if it doesn't matter materially to your case for either side, don't do it. That's not the design of this practice direction. It's about getting better evidence for what matters. But my counsel, and I certainly would adopt what His Honour Justice Badice said in relation to DNA, and that's why the court's going to start to narrow the DNA issues. Because at the moment, that scientific community is burdened with too much work. They just simply cannot do all the work that they have. Again, this practice direction is designed to get more accurate, better, comprehensive reports for what matters.
And just to underscore one aspect of it, the request, once you get a report, a primary report, further expert opinions, not just there for the asking. In a sense it is, because that's what you need to do, is to ask for it. But the Crown will consider the request. And if it's too broad or not narrowly enough focused, or in the opinion of the Crown irrelevant to the merits of the case, the Crown will say no. And it's likely the court might agree, because that's the only place you can go. So the court will be interested in narrowing the issue, because that's what, as Justice Badice has said, is so important, particularly given the problems with DNA. But also the whole focus of the practice direction is about doing precisely that. It's not about providing some avenue for a second opinion. It's about providing an avenue for an expert opinion on a particular aspect of the case. Now, are there any questions? Not so far? Yes. So we've got a microphone here. I don't know whether it's going to work, but no, stay there, so. Yeah, no, it's all right. Well,
Just act like we can hear you.
yeah. Yes.
If the report that we received sort of sets out the limitations and the issues and the empirical data about the testing, is that something that could then feature in the expert evidence bench book about those limitations and the jury being informed of them?
That'd be really generic, wouldn't it? If that was the case. What is intended is not merely an expression of limitations inherent in a particular methodology, but what were the limitations for this particular method applied in this way to this particular sample? So yes, you'll get a lot of information from reading through the reports, but it's meant to be specific to the case. Useless if it isn't. If you get generalisations, well, we run into all sorts of problems, don't you? So that's not the intent of it at all.
It's more about just everyone understanding what it's based, but the limitations that one needs to explore before it then gives the ears of a jury.
And whether the method's scientifically valid, if so, how do we know that? Whether the test is proficient, how do we know that? It is onerous. It will be onerous. There's no doubt about that. But it is so important. It may also give rise to more reports being the subject of grants of aid to consider the opinions that are expressed in primary reports, because they become more amenable to a desktop review if they've got all the information in it. So again, the experience in Victoria is that, as I understand it, that happens more than it did before. Yeah. Chris.
Is it proposed that the court will supervise this in a sense, or is there some sort of sanction for non-compliance? And how practically do we ensure we get what's hidden in a footnote?
Sorry.
Confused.
Oh, well, it's just a matter of bringing in a 590AA application and say, here's the request. Here's our application. Here's the affidavit. Here's the report. Here's the letter. This is the response. And then you could expect in appropriate case an order's made. Is that what you mean?
Yes, that's what I was asking.
Yeah.
Also, who pays for the two experts to produce a joint report?
Well, that's a great question, and that's subject to agreement between the parties. But if necessary, the court will resolve that. So that would depend on how well heeled an accused is, I suppose, whether the person's legally aided, all sorts of things. But that'll only be the case where there's reports or experts on both sides of the record. And as we all know, that's quite rare.
Yeah, I certainly can see places where that would be very helpful, but two experts taking time out of their diary to meet and then do a report jointly, they're going to send us a bill.
Well, I've got no doubt they'll send a bill. It's a question of who pays it. So at the moment, the Crown have the burden of doing all of that. So they would, I think, be responsible for part of that. But you can't commit either way, Philip. Yeah. So if we get that situation where there is a joint report, it means an expert's been retained by the defence, funded by the defence, owing all the same duties and obligations under the practice direction, by the way, and producing a report that complies with the practice direction. And then if you get to the point where a joint report's considered to be useful, then unless you can agree, the court would have to decide who pays.
I would think, Chris, it also depends upon how narrow the issue is. I mean, I from an autopsy report, I would commonly think if the neuropathology is important, and you know what Robertson will generally, the pathologist expresses the opinion based upon the information they got from their neuropathologist. That's a good example of where we might want to interrogate the expert on a particular field of the autopsy. And generally, they've been peer reviewed. So that might be an example where we would get and already have the information where we get two experts giving a joint report.
Yeah, or it may be an expert that's got nothing to do with the process at all, that is retained on a narrow point. I gave the example of causation, cause of death. Here's something thrown up at autopsy. Is there a significant possibility that that was responsible for death rather than this? Yeah. Yes.
This is maybe too specific. I think on the first page of the direction, reference to the courts of issuance for that legislation. Are there any particular types of report the drafters were contemplating with that?
The report's being excluded.
It's not intended to affect the issue.
For sentence hearings, for example. Yeah, so commonly reports from psychologists, sometimes psychiatrists, are tendered on sentence. It's not meant to cover those. They're typical. Any other types of acts or experts? Mainly that. We didn't want to impose a regime on the experts who give reports routinely for the purposes of sentence. Yeah. Does that answer your question? All right. Any other questions? Not necessarily for me, from the panel or Justice Badiz? Yeah. Oh, okay.
It concerns paragraph 32 of the practice direction, which talks about settling the conditions upon which an expert might be interviewed by one or the other party.
Yeah.
Most of the time, at least in my experience, when I've asked to speak to a prosecution expert, there's no problem. I speak to that expert privately, but from time to time I have had prosecutors say, no, I would like to be present, or I would like my client to be present. And I see here that the direction, the practice direction contemplates the court resolving disputes.
If there is a dispute.
How is that? Do you envisage that working in practice?
Well, I think the practice you've indicated has been going since Adam was a boy, the defence contacting an expert and speaking to the expert, and that will no doubt continue. But if you have a problem with the expert speaking to you, you can call or contact the expert. There's facility under the practice direction to ask for contact details. The practice direction also then says the Crown needs to notify the expert that that's been done. So, in other words, expect a call. And then the meeting can be arranged. It's not meant to say any communication between the defence and the expert has to be in accordance with the practice direction.
I was really more thinking of the situation where the expert was quite happy to speak to the defence and was available, but the Crown was insisting that someone from their side be present when the interview took place.
Yeah. So
now, just wondering how that would work in practice. Do you see the court as having the power to make orders about who can or can't be present?
The court would, if necessary, make orders. To give you an example, there may be some aspect that you want to raise with the Crown expert that goes to an aspect of your defence that you're not particularly keen on highlighting at that stage of the matter. That may be a reason why you don't want the Crown present. I'm just speculating, but yeah, if there's a dispute, if the Crown's saying, yeah, you can speak to this expert, but we want to be there, and you say, well, no, we don't want you to be there, then the only way to resolve it is to go to the court. It's a fairly straightforward application, though.
Can I just say something about hot tubbing? I have to say that when I was I was never a fan of hot tubbing. My experience was it was usually produce the lowest common denominator rather than the best evidence. And one of the things you do need to keep in mind is it needs to be very well prepared for it to work. And that means that the judge has to have a lot of control over the process and for everybody to know where it is going with the experts. It's one of those areas where it's quite interesting to see that it works very well, for example, say in planning and environment type cases, but that's because the same experts are giving evidence all the time. They understand that their credibility is on the line here, so it works very well. As you get more and more people who are so-called experts in that field coming every now and then, it seems to lose its benefits in the spectacle. So just when you are going down that road, it is very important that you prepare well if it's to have any chance of being successful. And that is one of the reasons why it probably won't be something I would have thought in front of the jury itself, which would take place. It's more likely to be that the experts are in the courtroom at the same time and hear the evidence, but individually give their evidence in respect of it.
Yes.
So there's a committee that's been formed for the expert evidence panel that relates to counterintuitive reasoning for sexual offences and also the affirmative consent law defendants. How will that interact with this practice direction?
Well, one of the problems that I see with that at the moment is there's many unknowns in relation to how those trials are going to be conducted, what changes might occur in relation to the process. So It may well be that there has to be carved out a special process depending on what is said in relation to that. But at the moment, the intention would be it's covered, if it's a case in this court, it's covered by the practice direction.
Can you see cases of that type going to the Supreme Court?
Occasionally, sex matters that are.
Where there's supply to a minor. Yeah, okay, I see what you mean. Yeah, no, it would apply. If it comes here, then the practice direction would apply. However, if it appears for some reason to be unworkable, then you can be relieved from the obligations under the practice direction. So again, that's something you need to assess on a case-by-case basis, I think. Any other? We've got a little bit of time, but we don't have to go to the end. We can finish early if you want. No other questions? Yes. Within 12 months, yeah.
You'll be after submissions from the bar and the parties about.
Yeah, absolutely. We'll go back to stakeholders.
Is it important to express any interest to see how it goes before they maybe?
Not to me personally, no, but I'm sure they're keeping a watchful eye. Yeah. But as you go, one of the questions that came up within the forensic evidence working group was there was very early on a misconception that it would apply to everything from the magistrates court right through to the Supreme Court. And of course that would just freeze the system if that had to be done in every case. So, but it does apply to every proceeding on indictment in this court. And we will keep a close eye on it. We'll review it. Yes, we'll get feedback from stakeholders and also the forensic evidence working group, because it's not just the lawyers, it's the scientists who will be working under this new regime, having to produce reports that are much more detailed than I've ever seen. Yes.
So on that point, and I guess increased workload, okay, has there been any extra funding allocated to forensics or to legal aid or any department, even to the court, to sort of deal with these cases?
No, but that's why we're charging $100 a head for you to get out. No, not that I'm aware of. Are you aware of any particular funding? No.
It is going to be a struggle because legal aid, of course, has finite dollars and they're being asked to fund a whole range of different initiatives along the way. But what we can say is in our discussions with forensic services, they are very keen to do it because they see that it'll actually improve the quality of the evidence and therefore the quality of their experts. So I don't think we're going to have a problem from their point of view. The struggle will probably be when there is a dispute, who's going to pay, and the difficulty that legal aid and the Director's Office, quite frankly, will have to find the money. That's something where, unfortunately, if we waited for money, we would not have any initiatives in anywhere. So we have to start off this way and work from there.
That'll be part of the retirement. And the answer is no. Neither the DPP or legal aid were given extra funding for this in particular, but part of the pilot project is to measure efficiencies as well, because there are other efficiencies from the court's perspective that might generate, there might be efficiencies seen from the Department of Justice, which we're both within, legal aid and DPP, in which overall the efficiencies in the system marry out, that they're seeing some benefit in relation to that. The focus here is on better information and better quality evidence being placed before the jury. And we could all give examples of coming across pseudoscience. I had a purported expert the police gave me that said that they could see a pattern on a toddler's face that matched the pillow that was in the particular house. That's the sort of thing that you interrogate. And I interrogated in that case and didn't end up calling it because I pointed out the carpet in a particular home had a pattern striation as well. And he then looked at it and went, oh, it could be that as well. That's the sort of thing we don't want happening that takes someone to interrogate them. That shouldn't be, we shouldn't need to do that with our experts. Our experts should say there are a number of scenarios that could give rise to that. And in the end, it was a bit of pseudoscience anyway that any human being could do and see it. You know, the markings on the face of a toddler, and there are all number of objects that you could have looked at and said, well, as a human being, maybe. So that's really what we're trying to cut.
Yeah, which is a limitation, isn't it? So it'd have to be expressed, and the expert would then start thinking about it, and then hopefully come to the conclusion it wasn't worth really expressing an opinion about that. So there's efficiencies inherent in requiring experts to do this. Yeah. Nothing else? Okay, well, thank you all for your attendance. As I said before, the turnout's been wonderful, very much appreciated. And could I thank Justice Badis, Mr. McCarthy, Mr. Hunter and Mr. Lodziak for their very valuable input. Thank you. As they say, you're free to go. Okay.